Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running a theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Hey everybody, welcome to Petty Playback. Day 3. We're actually on day 3. We don't have to make up anything but like an hour. I thought I was doing so good. I was gonna be on time. I was gonna be early. I was like, I'm good. Then the little threw my phone. And then she went in timeout. And then she cried. And as she cried, a series of events cascaded that I had to do some cleanup, including 2 change of wardrobes, cleanup of the timeout corner, cleanup of the timeout corner's path to the bathroom, cleanup of my bathroom, and here we are 6 minutes late.
Oh, wow.
So I was like, we're going to start like 10 minutes early. We're going to catch up to normal speed. We're going to go for a couple hours because I don't think I'm going to hit up the whole thing today because just for reasons like my brain just cannot function on regular speed. So we have to be a little bit behind. But like, y'all, the last half an hour of my life has been absolute chaos. Tears. She is fine now. She is eating Nutella toast. She is watching some Bluey. We are doing okay. However, the last absolute 30 minutes of my life have been pure chaos. And to add insult to injury, the person who was supposed to install my dishwasher and my microwave was supposed to be here between 1 and 4. It is 4:07, and guess who is not here? And guess who has not contacted Mr. Squid to say where they are in relation to anything. So we having a day. We're just having a day. And Flash fans apparently having a day too.
Yeah, audio always starts out weird. Sometimes it works, sometimes it's like, nope.
2 to 5 due to their increase. Oh, I just got a text from Mr. Squid like 10 minutes ago, and I didn't see it because of the utter chaos. The items were picked up by the installer at 3:19. The schedule was changed from 2 to 5 due to increased workload. Well, it's going to be like 5 o'clock. So
I hate when people do that. They like, they give a window. Like, we'll be here from 10 to 3. They end up coming at 7 p.m.
So we're just having a day. And thank you, maybe not. I did see before the YouTube stream crashed, the YouTube chat crashed, that maybe not gifted 20 memberships. I appreciate that. Thanks for keeping
Oh,
the chat
cool.
green. Thanks for ensuring that I don't have to sit through this shit for free. Fuck. I have caffeine because for reasons. Y'all, your girl is tired. Mentally, physically, we're redoing 2 channels. We're rebranding 2 channels. The other channel is up to 448 subscribers.
cool.
So if you have
Great.
not checked it out, please do. But we are going to get this effing show on the road because, well, yeah.
We got Nesta, and we probably gonna have to deal with her in real time.
About that. Yeah. So we are on day 3. They didn't start until 1 o'clock, which is 3 o'clock our time. So it's
I
a
wonder
2-hour
why-
time difference from Utah to here.
I wonder why they started it. Maybe Judge Graff had a docket this morning.
He might have had something going on. You never know. But we are moving us down. Let's see. Picture in picture. We're going to edit. We're going to move us here. So we block. Whoa. Wrong one. That one in the center. We need to move. Whoa.
It took it away completely.
I know. I'm just broken. This is what is happening with my brain right now. Whee. So this is what is absolutely happening with my brain. It is totally. Whoop. We are. You want K-pop? I want my brain to work properly, but we all can't get what we want now, can we? K-pops? No, you cannot have cake pops. Nope. Mama's putting her mama foot down with that one. No. Hold on. Go wipe your face. No. You got Nutella all over your face. You got Nutella all over your face, boo. All right. And now us, we are going to go down here and cover up the Law and Crime logo.
Yeah.
Because
I wish the other feet worked better, but they don't know.
We just all over the place today. Hold on to your hats, people. Squid is exhausted. Go wipe your face. You wipe your face, you can come up here. Daddy is not home yet. All right, we are going to get this show on the road. I have us at 1.3.
576, State of Utah versus Tyler James Robinson.
Or 1.4.
Your appearances.
Ryan McBride, Lauren Hunt, David Sturgill from State, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
And they are not
Kathy
speaking to the
Nestor,
mics
Richard
yet.
Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's
That's
present
for
in the
her.
room, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of the victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol, to maintain security and decorum,
Yep,
any
don't
individual
care.
who exits
Yeah, that normal.
Same old.
so please come and sleep today.
Media people.
Present
Yep.
courtroom.
I should have skipped through this.
They are entitled to time on their heads and shall not make gestures. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m.
Okay.
I raise this as simply a reminder for the parties, particularly given that we have now reached
So
the
we
midpoint
got
of this week. I
2 more
recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately. So each
AKA, don't bring trial problems into a preliminary hearing that is only probable cause. AKA, Michael Burt.
Him sped up makes it sound like him yelling. I like it.
Him sped up makes it sound like he's a normal person. Like Judge Graff, I have nothing against you, sir. You seem like a very nice person. However, you are a very nice person. And sometimes there is no room for niceties in a courtroom. You need to put your foot up proverbial backsides when it comes to managing your courtroom. AKA, don't let these motherfucking attorneys push you around like they own the place, because they don't. They're from California. They don't like you.
But to handle Michael Burt, all you have to do is look at a judge named Judge Stanley M. Weisberg. You'll understand if you ever see this.
And that is why one of the reasons that Flash Fan is here, because he knows these attorneys, these defense attorneys, better than anyone.
Judge
He
Weisberg
probably knows these attorneys better than their parents.
Judge Weisberg would have been all right. Objection overruled. Let's proceed.
It's just one of those things that the defense is trying to stall, and the defense is trying to make this a trial. And this is not a trial. For those of you who have no idea what a preliminary hearing, it is probable cause. Hearsay is allowed all over the country every day. So when you hear the defense bitch about hearsay, suck it up, Buttercup. Hearsay is allowed. The Utah Supreme Court told them that they weren't even going to fucking hear their arguments because it was a waste of their time. They are trying to bring shit in that is not appropriate for a probable cause hearing. But yet here the fuck we are. 5 days when these usually take 2 hours.
2 to 4, man. As long as I've seen in normal circumstances, it's about maybe 9 o'clock to about 1 o'clock, 2 o'clock, maybe.
This right here. Flash Fan is our voice of knowledge and reason. That's the truth. Truer words have never been spoken. I tell people to logic things out before they react, but here I am reacting because my logic is telling me that these people are fucking stupid. And somebody needs to say it.
Each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First,
AKA, give me a roadmap to tell me how the long fuck this is going to take.
Thank you, Your Honor. We
Don't
anticipate
waste my
presenting
time.
evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Okay, so maybe tomorrow it'll be over.
Good afternoon, Your Honor.
Good afternoon,
Michael
Mr.
Berg for Mr. Robinson. Judge, we have 2 remaining witnesses, Ms. Oliver from the ATF and Ms. Carner, also from the ATF.
They're going to talk about the bullet.
All right, and to both parties, thank you, I
Thank you.
appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge. I just want to highlight one issue for the court because it may be
No bad. Okay.
that the court wants to do some
We
time
haven't heard
management.
much from you.
The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions
God,
of it are
this
going to be
annoys me
even
so
in a preliminary
much.
hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state.
I have
so the
no
state could
problem with like
raise any
this
concerns
like
about the accuracy of the
timeline, but
transcript.
it's
That's
like
not
the
an issue.
at the
The
judge.
admissibility of portions of the
pisses me
video,
off.
the issue is about 20 pages, maybe 22 pages. So to use court time for the
Like doing this is like setting up a timeline. Like you talk this, you say this, you say this, you say this. Like, hey, we're gonna do this, and kind of it sets like a timeline. But when you do this,
That's just like pointing at them. Like it's your fault, Your Honor, just pointing straight at
how to annoy me in 2.5 seconds.
court to look at the proposed redactions.
See, like
may,
even this
be
doesn't bother me
indicative
because
of-
it's like
of the time. I'm not telling
like a
saying the court
timeline.
to do it. I'm just saying we may not want to do it between
But it's
9 and
this.
noon and 1 and 5 tomorrow or Friday. But it's going to come up today, and so the question will be, when does the court want to engage in the process of reviewing the 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
That's a good point, Jeffrey. Why is
No,
this
the
only
state
coming
has
up now?
received the proposed redactions, and we are
Yeah,
prepared to address
it's in
them
court
when
today.
that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right, well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you.
You've had 3
All
days.
right, does either party require the benefit of the record before we begin? To the state.
Is your face clean?
No, it's Daddy.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence, except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles, really, at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So in summary, the court can, and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so, and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. Oh, I see you. Okay.
Briefly, Your Honor, I'm sorry, I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps: admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other may say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
Yeah.
All right. The court acknowledges that the exclusionary rule is in effect at this time. Any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there's a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay.
Go so many places with this.
Again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
That's the answer for everything.
All right, if all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on.
All right, I'm skipping this. Law and crime tech,
And if we could borrow
courtroom
somebody
tech
to do that,
issues.
witness
Stuff.
monitor as well, so we could pause us any security and look at that TV. Again, transparency needs to be viewable. All right. Log in to project. That may be the issue.
Mr. Ellis is plugged in.
All right. I appreciate it. Looks like something for the now, the media, if you can see that TV. If you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right. Ms. Hunt. Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall
We've
give is
seen
the
her
truth, the court,
before, this
will be the truth,
prosecutor.
the whole truth,
She recently got a second-degree
All right.
conviction
Agent, if
against
you would mind
Megan
having a seat to your
Stonewall.
left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record.
She actually tried to go for first degree, but the jury
Could you
said,
please state your name and spell your last for the record?
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification. Any peace officer in the state of Utah, local, state, county, I'll go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF PSN task force focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer of War Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I've worked anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with FBI Public Corruptions Task Force as well.
Sorry, I
Is
didn't
that
make
all
us
on the job
bigger.
training, or did you receive specific?
I couldn't stop staring at the top of his bald head, right over the top of the. So I had to make us bigger for the time being, because I really could not stop staring at just the tip of his bald head. Just it's very shiny this afternoon. Sorry, I must apologize to chat for that. I couldn't.
you got to thank for bald heads.
99. And when Mr. Squid gets home, since I'd already made dinner, I will be opening a drink if we have to listen to Nestor. I do have more wine coolers in the fridge, those Seagrams, and I will be opening one. I do not drink when I'm alone with my child, just in case I have to take her somewhere. However, when Mr. Squid gets home, if we're still going and I have to listen to Kathy Nestor, actually, Kathy Nestor has been the least annoying today because she hasn't spoken.
Yeah, thankfully, we only heard from her on day one. We haven't heard from her yesterday and so far today.
Yeah. Yeah. So back to this.
We mostly heard from no
training
back
or conferences, things like that.
Yeah, throughout the years, various trainings, conferences for all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm Faro certified. It's a 3D Faro scan of crime scenes.
What's a Faro scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm been certified as a forensic interview in the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for.
He said Hull, but it sounded like he said a-hole. I know what he said, but it's like, y'all, I know what he said, but yeah. Yeah.
Accent.
For it. Ultimately, you direct the cases as you go along. Make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case. Yes.
Has this particular case been large?
Yes, it has.
The biggest case in the country.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Warren Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
And explosives.
All right. I know a lot about what we've... So as a case agent, have you...
To my YouTube overlords, I'm just literally saying the name of the branch of government, or it's not technically a branch of government, it's a branch of bureaucracy. And hey, Stacy, how are you? Welcome to the shit show. You know.
Hey.
You've been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elshulz requesting that I travel to St. George.
Who is Sergeant Elshulz? What agency is Sergeant Elshulz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
Okay, I'm not gonna lie. I don't hate this guy. He's got an important job, but had turned himself in and will turn himself in are 2 different things, and is a big ass distinction in a court.
Yeah.
Get it right. This is not the time to misspeak. I mean, I know he's probably got a lot going on, but that'd be a very important distinction to make.
In hindsight, that probably won't matter in the long run to get him bound up for trial.
No, but just FYI, if you're going to testify, make sure you know, because that would be something the defense would pick,
Yeah.
especially this defense would pick
Oh,
apart.
Yeah.
And they probably will.
Yeah. If I know
If
the
I
thing-
picked that out, so did they.
Yeah.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elshulz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the 2 pilots
And who is Ryan McBride?
with the Utah County Attorney's Office.
What time did you arrive in St. George?
Goatee guy.
We landed probably about 11:30 p.m. at the St. George airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
We did. We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents within SBI assigned to the Southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes,
What time did you arrive there?
probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the SOC interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
Boomer moment. And that right there should be enough to bound him over for trial. He turned himself in.
Yeah.
If you didn't do it, why would you turn yourself in?
Yeah.
I mean, I got
If a
nothing
crime
else
is committed and I know I'm innocent, I'm not gonna turn myself in because I ain't do it.
because I didn't do it. I mean, it's not a mic drop moment, but it kind of is. Like, if you did not do it, why did you turn yourself in?
Although I did hear, I saw some months ago and I forgot about it until just now. Apparently somebody falsely confessed to it. Cause I remember seeing a court hearing a while back with like falsely confessed accused Charlie Kirk on the live in court. I'm like, really?
He should be listening to questions but answer to the judge, according to my sources. Yeah, I understand that, and I think he is. I'm annoyed when people do that because it's like I prefer to just look at the lawyer or have people look at the lawyer because I think Amber Heard, and it gets really awkward. Like that last woman from Quantico when she kept turning her head to look at the judge. I get it, but it's so like.
So y'all would hate the South African court system because over there they had to address everything to the judge. So you ask, say, for did I ask you like, what did you eat for lunch? You like, I had a barbecue pulled pork, my lord, because that's how they address the judge in South Africa. But every answer they say, they can't just say it normally. They have to address the judge at the end. So because he's the fact finder. I'm like, yeah, that's weird.
Yeah, I get that, but there's a way to do it and like casually look over and address the jury without being like every time because when you're cranking it just looks awkward and unnatural and weird, and especially when people do it and they're looking at a jury and it's like every freaking question, even if it's a yes, no, like it just like it gives me Amber Heard vibes because it was like that awkward, just bizarre. If someone was testifying and they kept looking at me and trying to make eye contact with me if I was on a jury, that would freak me out.
Yeah.
Like just talk to the person who's asking you questions. Like look at me and acknowledge me every once in a while. But like, don't look at me every single time. Don't look at us every single time because that's creepy and awkward, especially if it's a one-word answer. It's
Or like, what got me was in South African the defense asked like, did you hear my question? And he was like, I'm trying to answer your question, my lord. I'm like, see, this is the problem. The judge didn't ask the question, the attorney did. So I'm like, this is weird.
it's just an awkward thing when it's like, especially if the jury or the judge is positioned like this way. Like I look at who's talking to me.
Yeah.
If you're the one talking to me, I'm gonna look at you. If the judge is the one talking to me, I'm gonna look at the judge. Like, I'm gonna look at, I'm gonna look around, but like, I'm gonna look at who's talking to me because that's to me a sign of respect. Looking at the jury or looking at the judge every time I'm answering a question that a lawyer asked me.
And we see that in some cases where they like, can you turn and face the jury when you ask them? I'm like, that's...
But maybe that's the military in me because if you looked at somebody else, it's like, no, I'm talking to you, mofo. Look at me. You don't look at anybody else. They're not answering questions. Like, they're not asking you. I'm asking you questions. You look at me when I'm talking to you. Like, that's how I grew up. That's how it was ingrained in me, and that's how it was ingrained in me in the military as well. When you look at the person and you address the person who is speaking to you.
Yeah, that my mom used to say every time I get in trouble, I'd be my head be that. She'd be like, look at me when I'm talking to you.
Yeah, that's that my mom was like that. And whenever I look away, it's like, no, they're not looking at you. They're not talking to you. He's not talking to you. You look at me when I'm talking to you. My dad was like that too. And so is the military. When you're getting your ass chewed or someone's asking you questions and basically interrogating your ass and you're like starting to wander, it's like, no, you look at me. I am the one asking you questions. You look at me as long as I am the one talking. So it's ingrained in me as a matter of respect to look at the person who is talking to you. I don't know. It's so weird. And also, if someone's asking me a question, that's the person who I'm going to address because that's the person who I'm giving the answer to. The jury didn't ask the question. The jury is taking notes and observing my answer to the question. They're not directly asking me. It's just, I don't know. It could be it could be weird, but like I might look at them because I'm going to look around. I keep my head on a swivel, situational awareness type of thing. But like at the same time, I'm going to just keep looking at who is talking to me.
Person who's addressing you, that's just natural. When you do it, it's like it's a natural. Like,
it's weird to go, even to look when someone is talking to you over here and you're giving the answer over here. It is just. It's weird. It's just weird. And it gives me Amber Heard vibes. You remember that? When she every freaking time. And it was like, my dog stepped on a bee. Like, I just every time. All right.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. Or I guess, how did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith.
Okay, this I have to address because this is one of my biggest pet peeves because the only people I saw that do this were doctors. Even when there's a translator, you don't look at the translator. Yeah, you look at the person who you're talking to.
Yep.
You don't look at the translator. The translator is invisible except to do their job is to translate. The only time you look at the translator is if something is lost in translation and you look at them to clarify something. But you are talking to the person.
Yeah, because correct me if I'm wrong, they even separate themselves because I seen when they're this testimony in court where there's an interpreter and the interpreter has a question, the interpreter speaking. The interpreter needs clarification. They refer to themselves in third person because they kind of like.
It would drive me absolutely up a wall, especially with sign language. It really drove me nuts with sign language interpreters because I was to the point back in the day when I didn't like the sign language interpreter was like, it was trivial for them to be there. Like I didn't need them for certain sessions because I was fluent enough to get me through certain sessions like ADL. Like if I'm doing a shower with a sign language patient, I don't need an interpreter there as the third person in a shower kind of a situation.
Oh, yeah.
I can get through addressing and abating and addressing tasks without, in a shower without a third person to sign. However, I hated when doctors would be like, tell the patient. No, how about you look at the patient and just let the interpreter do their job? Because the patient is also reading your lips. It's a huge deal. It's a huge deal. Tell the patient. Well, how about you just talk naturally and let the interpreter work? Or with deaf patients, when the doctors used to yell at the patient, I'm like, you realize they're not hard of hearing, they're deaf. They can't, like, I told the doctor one time because he was yelling at a patient in my busy gym where there was like 30 other patients. And I was like, you realize you don't have to yell. He cannot hear you at all. He is not hard of hearing. He is deaf.
I hated that when my mom was in the hospital the 2 weeks before she passed, she had a stroke. Now she could hear, she was still functional, but you had the doctor yelling, "Ma'am, do you want to do this?" I'm like, "He can hear you, idiot."
I gotta restart this and take her to the bathroom because apparently she doesn't want to go, but she's got to pee. So I gotta get going.
Yep.
I'm gonna restart this and mute myself.
And also, at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously.
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
It would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that. You stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, can I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
Why you say a moment? Just say, may we confer?
That may happen a couple more times as we go through exhibits because of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt.
This isn't the trial. This is a
the other two
preliminary
steps,
hearing. It's supposed to be over
We
by
would ask to admit
Friday.
it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a
They
longer
making it look like the trial, but it's not.
image with audio, and we've agreed to a shorter image without audio.
Yeah.
And so-
Well, I have seen some people like I was finding I went on to Rumble and Rumble's homepage. There are a few people who are calling this a trial.
Yeah.
Like Drew Hernandez said Tyler Robinson pretrial. It's not even a pretrial hearing. It's a preliminary hearing. There's a big difference between a pretrial and a preliminary. And then the quartering, in his infinite freaking wisdom, said New Insane Race Hoax, and then Tyler Robinson Trial is the title of his show. And it's like there's a couple others that aren't showing up this time that they did on the first one, or the first time I opened it up. But it was like, y'all, like,
Yeah,
what?
this stuff isn't going to trial for years, probably.
I'm like, there are a few people who are calling this either the trial or a pre-trial hearing. And technically speaking, it is a pre-trial hearing because it is a
Before trial.
before it is a hearing before the trial, but it is technically a preliminary hearing.
I know my sister asked, yeah, the shit I did the Charlie Kirk trial stuff. I'm like, nah, well, no, not the trial. Per se.
Yeah, but when you have this is the very definition of how many people are streaming this that don't stream trials or don't trial watch or don't court watch or read court filings.
Like for instance, there's I don't know if she's from Fox News or CNN, some reporter, Megan Kelly, she's streaming it. I'm like, aren't you a reporter on television? Why are you streaming?
No, she hasn't worked for Fox News in like a decade.
Oh.
So, but there are people like Jinx Sip. I've never heard of this person. Tyler Robinson prelim hearing day 3. Viva Fry, Tyler Robinson prelim hearing. Like there's a bunch of people who actually like. Well, Viva Fry is a lawyer, so like of course he's gonna call it what it is. But there's a bunch of people who
any of these people
who are actually calling it what it is. But at the same time, there are a bunch of people who are
like
not calling it.
Like the Tyler Robinson trial. I'm like, no, that's not accurate.
Yeah. It's interesting how many people are calling it what it is, but it's like how many people don't trial watch.
I mean, I'm willing to overlook that slight slip up because even though I know they
yeah, like
because it's about days, I'm like it's about the length of an actual trial.
And if you want to hear quartering stuff, check out Camelot 331 about a month ago. He did a lot of stuff with Yellow Flash. That there was a lot of stuff for yes, it's the longest probable cause hearing ever. This is probably not the world record for probable cause hearings, but it's the longest one I have personally ever witnessed.
The longest one, actually, there was one longer that was mentioned in one of these pretrial hearings. They were arguing about a case in one of the hearings before leading up to the preliminary, and one of the attorneys said something about they were arguing over a 41-day preliminary hearing. I'm like, 41 days for what?
And remember how I said Flash fan knows a lot of things that I will never know, and I don't know how he knows what he knows? That's one of those. How do you know that? like I said, Flash, when you were like, I don't know what to talk about other than like documents. It's how you find what you find. How you research and find what you find, because it is fascinating because you tell me things and I'm like, where the hell did you even find that? Like, how did you even find that information? Or you'll find documents and I was like, I've been looking for those documents for like a month. Where did you find that? Oh, right here. Like, I just Googled it. Apparently, your Google's different from mine.
I am a patient searcher. So, like, I was searching for the Menendez retrial transcript. I started searching in 2022. No, mid-2023, I was searching for those trial transcripts. And I didn't find them till mid-2025. So, I'm patient. I don't give up searching. I'm determined to find stuff.
Like I said, you think you don't have content. You have there is a world of content in your brain. I can guarantee it because you are a fascinating human being.
Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward.
I want to see what people said about the longest preliminary.
Let me just confer with my paralegal.
What was the longest?
Has no audio, so we would like to admit and publish it at this time.
Right, State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the
I don't
All
care.
right, with that, can you do that? All right, State's Exhibit 15.
I can appreciate the fact, though. I can give him a scintilla of credit that he said we don't need to rehash it. I will give Novak a scintilla of credit, the slightest bit, and that is it.
All right, the longest preliminary
And Agent
hearing
Davis, who are we
was
seeing here?
That's Tyler Robinson.
the Martin Preschool
Although we are
case.
watching it on video, what is he wearing at this
It
time?
was 18 to
So
20
a
months.
dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol in front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes, I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested
Skinny
in the
little
early
shit.
hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was so prior to
Did y'all hear that? She picked Nana out of the crowd. It's Nana.
It's not
You ain't even,
mine.
you pulled her comment up and she saw.
It's not
like our arriving to the St. George to the Washington County Sheriff's Office, his cell phone was seized and taken from his person, but that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated, when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of
Okay,
that
so
that
this
morning,
is
and I was the
rush
booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification, the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me
She
exact
knows your
addresses, but
ABCs.
generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a close family friend.
And what was his involvement here?
So he helped facilitate working with Tyler's parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Durfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, it's not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George, well, it was the St. George courthouse there. They met and discussed briefly, just to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour, where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admission or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward, laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, we see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So,
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
Yeah, and Gail, I don't have her read much on stream because people are weird.
And you read some
Misspoke. It's not 14.1, it's just Exhibit 14. So if we can place that again on the screen for the witness only. Does it depict, is it fair and accurate from what you remember?
yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission.
They agreed on
State's
something?
Exhibit 14 into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, can I have a copy of it? What I have is the unredacted version, so I want to review it before I make that decision.
I'm just skipping where the judge is reviewing stuff because
Standing objections by defense concerning 1102's court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge.
thank you.
All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was down on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LoSI building is, it's a building directly kind of south and east of there, from the LoSI.
Southeast from the LoSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent, Agent Betschneider. There was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet, with, ammunition with the bullet.
Did you learn if this 223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been
Still had a primer.
Fired. It still had the bullet projectile in the end. Still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Betschneider.
Get your feet off my desk.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. Are you, you've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Oh,
Also known as the furry.
Wow.
No, that's not a joke. He's
Oh.
he's the furry. When people were referring to Tyler Robinson as a furry, as far as we know, Tyler Robinson's not the furry, but Lance was, or is.
I think they're about to get into his recorded statement now.
Was he interviewed as part of this investigation?
He was.
How many times?
She
2
did.
times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware if Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but
Ultimately, a buccal swab was obtained from Mr. Twiggs?
yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview with Mr. Twiggs.
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
Was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
People
Was
did
Mr. Twiggs
say
given
something about
use
that
immunity?
roommate should be
Yes, he was.
charged and stuff. I don't know what his role, what their role is, or whatever, but people should be charged.
I don't, and I guess it all depends on if he contributed to the delinquency of his roommate or boyfriend,
Yeah.
because there are rumors or confirmed that they were not roommates; they were in a relationship.
Yeah. I also heard that.
So there's a lot to unpack with this, and this is one of the things where you have to separate the facts of the case from how you feel about the case. I could care less that Lance Twiggs is a furry. I could care less that Tyler Robinson was dating his roommate. That has absolutely nothing to do with the fact that I believe he unalived somebody. Those two things can be true at once.
Yep.
So we have to. So when you're watching this and we talk about the fact that Lance Twiggs is a furry, Tyler Robinson is gay, or at least bisexual. Neither one of those is a judgment. Those are facts.
Yeah.
Don't
And,
care either way.
and the
You do what you
defense is objecting to that was these are one of the issues that was appealed and was slapped down by the Utah Supreme Court last week as well. So apparently they're still mad about that because she said they're going to have objections. So
Yeah, well, tough tits. I was waiting
what
for her to
offices?
repeat that.
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twig's interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, I do.
We've talked about 1102 statements. We talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition
Perjury.
given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
Yes, Angel.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time
1102, more
to
hearsay.
address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense
they haven't
is
officially ejected yet.
proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it.
Of course.
In total, redactions appear on
holy hell.
16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And
this is how you know they're toddlers throwing temper tantrums, because they're not only a day late and $1 short, but they want what they want when they want it, and they don't give a damn about the fact that this has already started. And they're going to make any excuse that it's the court's fault, it's the state's fault, because there's so much evidence. No, you knew about this for weeks, months.
They trying to worry about presenting their case to the court, and y'all like, we want this. Like, come on, man.
They're so worried about presenting their case to the media as if this is the trial that they forgot that this is the probable cause hearing. And I think enough probable cause has been shown to bound us over for trial already.
Yeah, the state probably really didn't need to go as far to go on with some of these witnesses.
No, the state needed probably like 4 hours.
Yep.
The state didn't need any witnesses.
The first 3 witnesses had done it.
I mean, honestly, this is so ridiculous at this point. It's a shit show and a circus, and this defense team is literally making a mockery of this court, and yet they're the ones that are like, the prosecution is going to the media, and this is all over social media. Yeah, because you're fucking ridiculous.
Then with this,
you are absolutely out of your damn minds. You are making a mockery of the court. You are taking advantage of the fact that people all over social media have absolutely no idea how our court system works, and you are taking advantage of that and making this courtroom look like a fucking circus, and that is on you. I am not a huge fan of prosecutors, but this prosecution team has been fairly contained
Yep.
and
It-
respectful in this hearing.
If
And
Judge Graff doesn't rein these defense attorneys in, this trial, if it gets there, and when it gets there, it's gonna go months because
especially with the way Bert likes to hear himself talk. All right, since speaking of people that like to hear themselves talk, I'm going to shut up now.
And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview. How the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so
you can't
we
redact
would
the video.
object just procedurally on those grounds.
That's gonna happen.
Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider. Again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is a quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence State's Exhibit 16,
Yes.
and as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits, so we would agree that this should not be captured by cameras and projected by the media outside of the courtroom, but we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So
I can
your
agree with
request
that.
Is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom, and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right, and in regards to this exhibit, is as State's Exhibit
I wanted the
16,
defense to object to
is there
that.
any portion of that recorded
Oh,
statement that
which
could
one
is that?
or the
Cannot wait.
1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, so turning to the defense, Mr. Novak.
Oh, here we go.
Got no.
So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry, the court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit.
I have to
which the court
speed his ass
is not,
up because he talks so fucking
inclined
slow.
to
He not Utah, but he
until the
talk-
moment, as the court has said many times, until the exhibit
Okay,
is
you want to see
presented.
what he sounds like at regular
So what we have
speed?
done is we have given
Oh.
The state. It's only a 20-page transcript. Excuse me. It's only a 20-page transcript.
He sounded better at 0.25 speed.
We have given the state
Hold
a
on.
transcript we prepared.
Hold on.
Given the state, it's only a 20-page transcript. Excuse me. It's only a 20-page transcript.
He pulled a Nesta from Monday.
We have given the state a transcript we prepared ahead of time so that the
Judge's
state
face. I'm sorry. This is
could-
hilarious to me.
We have given given the state. It's only a 20-page transcript. Excuse me. It's only a 20-page transcript.
Try so hard.
We have given the state a transcript we prepared
He talks slower
ahead
than
of
the
time
judge.
so that the state could
And
make sure
he's
that the transcript is accurate. The
California.
state has
That's
never
why.
said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the
Must
state
be a
doesn't have
Valley
any
girl.
dispute that the transcript is an accurate transcription of Mr. Twiggs recorded at 11:02.
No, that was petty.
There's no
but
surprise here.
Welcome to Petty Playback.
There's been all
I
Monday
can't
evening,
help
all Tuesday,
myself.
This morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court
surprise.
signaled should be done, which is
But
if
you
a time
sent
and
them a
exhibit is
transcript on
proffered,
Monday
objections
evening,
shall be made.
man.
This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court
Oh
will
my God. Right
consider-
to a fair trial is the new drinking game.
Yeah.
I,
That-
I know that was petty, y'all. But
That's the right to
Hi,
a fair
me,
trial.
I'm
Is the right to a fair trial is their version of subject matter jurisdiction or grounds. Like,
they are skewing what it means, and they are making. See, and this is the thing. If you ask the average person who is watching this, who does not watch trials, they cannot give you the definition of what a fair trial is.
Yep.
There are people who court watch or who are involved in certain cases who still can't tell you what a definition of a fair trial is because every time the judge rules against the person they like, they get butthurt. And they think the world is coming to a fucking end because the judge ruled against one thing. And it's like, no. You will not get everything to go your way all the time.
that's not
Welcome
a
to the
court-
back and forth that is the court system.
If the court system worked right the way they wanted it to, where every chance they got they won every time, then that would be an unfair trial.
That's not a democracy or a constitutional republic. That's a dictatorship. Yeah. No, he's not home yet. He doesn't get home. He doesn't even get off work for another couple minutes.
those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because
I do feel the need to check my camera
The-
though.
categories of objections that we have to
Dude,
this
did I put him
video
back on
recording,
normal?
I'm going to talk about it a little
No.
bit so that the court understands why Ms.
He
Hunt's
talked
suggestion
about stand up.
that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 11.
Too late.
The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single
Guess
statement
what?
of
It's
Mr.
not a
Twiggs-
trial.
Mr.
It's a
Twiggs is
probable
just an
cause
affirmation
hearing,
of
you
what Mr. McBride
dipshit.
says, but the vast
Get
majority
over
of
it. Suck it up, Buttercup. Move the fuck
There are
on.
also portions
Even
of
in
this
it-
1102
even in
where
this
Mr.
statement,
McBride
well,
is basically testifying as to what other exhibits that this court will
the
see.
courtroom.
I'm not understanding the point of this dog and pony show. We know he's going to trial.
I kind of like how, again, I'll go to the foreign case, but somebody said something that the defense judge, well, the state said this, that they were going to do this and they didn't do this yet. And it's just like, look, if it's wrong, you know what to do. You're the lawyer, you appeal it. Or if it's wrong, take advantage of it.
I'm just not sure what the point of this dog and freaking pony show is because we all know he's going to trial.
Yeah.
They have shown enough evidence already. The video.
It's
He
too much.
turned himself in.
It's too much evidence here. If he doesn't get bound over, that would make it unfair. At this point,
We know he's going to trial. It's like, y'all, just save your shit and save your objections for the next 50 freaking different documents you're gonna put in.
pre-trial hearings.
Move the hell on. Stop wasting the court's time. Yeah, it's all for the media. It's all for the media. But I do think more people, I hopefully think that this will reduce some of the conspiracy theories of like, he can't make it across the roof in 15 or whatever the case may be. We saw the video. Whether it's Tyler Robinson remains to be proven. However, somebody made it across that roof pretty damn quickly. So, would you like to dispel that one for me? Yeah, this is a dog and pony show. Except for dogs and ponies are cute, and none of these fucking people are.
Say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I'm not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not
You're
relevant.
not relevant.
There are portions of it
Move
which I think,
on.
especially through broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because
Too
I went
late.
to great lengths to provide the
You
state with a
said
transcript,
to him on
with
Monday
a
night,
proposed
when they
redacted transcript. And
call
in fact,
it.
today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do
Now
that
they
without
gotta
compared
take
to
time out of their
the other thing I
job,
want to say is
talking
that
to witnesses
if
to
the
worry
court did
about
order,
whatever you want
ultimately,
to
that portions of it would be broadcast in any way, in the courtroom, outside the courtroom. We're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible.
This
It's
judge
easier to do
looks
on
like
video.
he's
So the transcript
annoyed.
is just a tool.
Look at the.
We have the ability right here in this courthouse to
Okay, I'm not a huge. There's body language. Okay, like everybody knows there are certain like. I'm not a huge believer in like that you're lying or you're telling the truth body language, but like you can tell when someone's annoyed. You can tell when someone's happy. There are just certain things about the eyes, someone's face, someone's posture when they are annoyed, happy, sad, angry, whatever. Try to make that face that the judge is making right now. That is not a natural face. Try to downturn. They say it takes more muscles to frown than it does to smile. It really does, because try to turn down the corners of your mouth. I dare you right now. Try it. Everybody in chat, try it. Tell me how freaking easy that is. That takes effort. This judge right now, that's his permanent face. If his mom was here, she'd be saying your face is going to stay like that. You know, you make that face, it's going to stay like that. I think his face is frozen. Because that takes freaking effort to downturn the corner of your. Like, I can't even do it. I probably can if I'm angry, but like just trying to make that face, I can't.
He's like, I want to stay so stoic so bad, but I can't do it. The judge is having an internal conflict, trying to stay impartial, trying to stay impressive.
I'm not frowning. I'm exercising my face. I'm going to use that one. I'm not silent. I just have nothing nice to say.
cut the video.
Or I'm
into
not
pieces that the court
quiet, I
deems
just have
admissible.
nothing nice
Mr.
to
Ellis tells
say.
me it'll probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's
Can he
Wednesday. and this
talk
court is
without
gonna
moving his
conclude this hearing
hands
by
just
Friday.
once?
So I've gone
It's a
beyond the
bad-
procedural issues. I've addressed. we
I mean,
think
I
the
talk
are
with my
admissible.
hands.
There's
Do
no
not get me
surprise.
wrong.
We followed exactly what
But,
the
like-
has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing. And
I
don't wanna hear
can
objections
talk
about it
without
until we're in
my
the middle of
hands.
the hearing. The litigation
He
over
can
whether
do it,
Section
but-
1102 is
Yeah,
constitutional.
he's doing
under Mr.
too much.
Robinson's federal
It's
due process
excessive.
rights and the other rights that were addressed. That litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to
But they
short
were
circuit this with a
preventing
procedural
it. What are
argument.
you talking about?
And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because because the exhibit contains significant content that is not admissible, even in a preliminary hearing. So I'm going to stop now. But I do want to go back and say that if
Even in
the
a
court
preliminary.
concluded that only Your Honor was going to review this exhibit,
face shouldn't be
and the Archer letter
admissible
rule
in
will
a
be extended to
preliminary.
this exhibit,
Now I'm
including that
just
it's
getting
not
day
going to be
3. I'm just getting
broadcast,
spicy.
then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before
I
I go.
don't.
So going to your
I'm
first
glad
point
he
in regards
do.
to this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like, I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has
we
wanted
ain't
to
got
look
time
at
for that.
transcripts line by line, word by word. We're
We
prepared to do
don't do
that,
that.
but I'm going to give the court categories
He just told you.
without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs.
He just told you at the beginning, we are running short on time. We are on day 3, and y'all, we have 5 days for this. Friday at 5 p.m.
It's 2 more
Y'all
days.
still can't freaking do this.
It's 2.5 days considering the fact that this day is mostly it's already afternoon for them.
Jesus. Y'all, I have other content. Hurry your shit up. I want to cover this because I've been covering this case. My ass was on camera crying my eyes out with Camelot, Outpost Nerd, and a couple other people talking about this case when it first happened. I was bawling my eyes out on stream. I don't ever do that with y'all.
Usually I find case you heard the Charlie Kirk kid. I'm like, who the heck is Charlie Kirk? I didn't even know who the guy was.
Exactly. So I've covered this from the start. So I'm with y'all on this. But these attorneys, man, what the absolute F is up with these people? Like,
There, Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
Sure.
because there are 2 exhibits that I'm very confident are coming. There are portions which are not relevant. There
you're
are
not
portions
relevant, sir.
which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the
You've
best evidence
already
rule,
spent 15 minutes,
which I think
where
also
they
includes
could've been
hearsay. We have relevance
testimony.
issues, and we have 403 issues.
Arguing
And so,
about
but what I'm saying is that those are all things that this court
We're
can
not
manage,
getting
as Ms. Hunt and Mr.
anywhere
Wright have taught us
today.
today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archer letter rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
You're
And
interfering
I
with
do-
his
I
right
do-
to a
I
speedy
heard exactly what the
trial.
court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had
It's
said to
not.
us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that is probably, for counsel,
Well, they weren't going to expect you to send
a
new
suggestion about how future hearings, where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins. so that the court knows these exhibits, there are no disputes. These exhibits, there are disputes. These are the disputes, and we don't have
Do
to
that
waste
the pre-trial
courtroom
suppression.
time
Don't do that.
bringing the court up to speed on what those concerns are. It can all be briefed ahead of time,
There are
and we're happy to do that.
there are so many
Well, then for the
different
last point,
hearings for
I wanna be
that.
clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in. But I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state, what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But
Tell them how you want to proceed.
as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
Thank you, Mr. Novak. Appreciate
You've
it.
been repeating yourself
You did
since Monday.
25 so-
Hoy.
Yes, thank you, Judge. And
Whew.
as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, and then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And
Oh, shut
as
up.
everyone knows from conducting
Y'all don't
No,
want to
you know
trials,
that you know that the judge is going to ask the media, and the media is going to request. She was just being formal and saying and giving them the opportunity to weigh in, because you know they're going to want to.
They have to. They the main ones to be asking for these hearings to be closed. So yes, they need to have their position heard too. You won't want if you need to respond, you won't want somebody to say, "Well, we don't want the defense to respond." That's no.
Yeah, if this is open, then yeah, I think it all should be open. But the defense wants to close everything because they only want things shown to the media that is good for their client. They don't want things shown to the media that is bad for their client. But if stuff is good for their client, then they're like, yeah, show it to everybody. Show it. And thanks to the 8 people who are hanging out with me on both Rumble and YouTube. I know this is long. I know there's so many people streaming it. So thanks for being here with me. I know it's long. I know this is not going to get many views. It's about dinner time for some people. But y'all are awesome. Thank you.
other types of proceedings, sidebars are not for the public. They're not for the public in real time.
You're a
They're not for
sidebar.
the public
That's not a
subsequently.
sidebar.
It
You're
is
talking about a hearing.
very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are
not
conducted at
that.
sidebar
You're
so
at the
that
purpose
witnesses,
you're
jurors,
talking
members of the
about.
public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings
I'm not a
conclude
lawyer. I
or the
know
court
what the
conducts
difference is
some
sidebar and a closed
closer
hearing.
analysis on a topic by topic basis. So
He's smarter
that's
than
what
us,
sidebars are about,
remember?
whether it's done
God,
in a
even
closed
the
hearing or an open
attorneys
hearing
need
through
Red
whisper.
Bull.
The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd, on behalf of the media.
See?
There you go.
A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. Can't be done in whisper. That can't be done with cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closure. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing. There may be exhibits that do not present significant pillars of support for the decision that.
And this right here is why I love YouTube. Because we can have fun together. Do I wish there were more people in here? Yeah. Do I wish there were people in here that would be in here for like a drama stream? And do I miss the people that no longer watch my content because I don't do drama streams? Yeah.
They not really your real fans anyway. If they were your real fans, it wouldn't matter what you cover.
Touche.
The court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video. The public hasn't seen this video. It seems to me that this appears likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those? Right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that we serve by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or keeping this recording from the people in the courtroom who are allowed to hear
you're not talking about closing to the media. You're talking about closing to every.
Under the rules that govern this proceeding, keep this as open as possible.
And Dale, I redirected to him on my first stream.
Access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. Make that important. We recognize its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Everybody's
Only,
sped up except for Novak because he's just so damn slow.
Additional assertion about why the court should handle this exhibit.
Do you get that? Everybody else sounds sped up and like chipmunks except for Novak. Novak sounds like he's talking at regular speed.
Archuleta, but I want to make that argument a sidebar. Because the whole point.
That's not a sidebar, you
trial.
dipshit. That's a closed
part of this argument in
hearing.
open
There's a
court.
difference.
It's a self-defeating exercise. So when the
He's
court
been an attorney for
resolves whether
over
it will hear
2
from us as a sidebar,
decades. How do you not know the difference?
All right. The issue is sidebar is public because the transcript's open. So just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing.
Yeah.
So we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
Thank you. All right. Right now, what we're going to go ahead and do.
Doesn't Novak look like Ben Stein? Except Ben Stein's competent. Doesn't he? You know who Ben Stein is, right?
I'm guessing some lawyer.
No, Ben Stein used to have a game. Ben Stein is a celebrity. Well, kind of. But he used to have a game show. Hold on. I'll Google him.
I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially.
Oh, yeah, he's a lawyer.
Exhibit. So that's going to give us.
Ben Stein is a lawyer.
I want to review that so I can be brought up to speed because the transcript, from what I understand,
I know I heard
a transcript with suggestions of what the defense wants to redact. Is that correct?
That's correct, Your Honor.
So here is Ben Stein.
Okay.
Doesn't Novak look like Ben Stein?
Kinda, yeah.
Except for Ben Stein's competent and funny and enjoyable.
I think I would get him mixed up with Ben Crump.
He was a speechwriter for Nixon and Ford.
Really? Wow. Okay.
I didn't know that.
That go
But
way back.
he used to have a game show. Oh yeah, he was Bueller. He was the guy in Bueller that said Bueller, Bueller,
Okay. Yeah.
Bueller. That was him.
Yeah. Okay.
So he used to have a game show. So he went to Yale Law.
Wow. Okay.
But yeah, yeah. So that's Ben Stein. But doesn't Novak look like Ben Stein?
That's gonna be kinda, yeah.
The proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions.
He wants everything private. Everything private.
Except for if it meets his narrative. But everything else,
Except for if it fits his narrative and makes his client look innocent. Yeah, win Ben Stein's money. Thank you. Thank you. I knew there was a game show because I watched it. It used to be on Game Show Network when that was actually like cool.
I've been watching. My mom used to watch Game Show Network. I haven't watched the Game Show Network in years.
He loves the sidebars.
It's not redacted through blackout.
Whereas
It's highlighted.
the rest
So
of his
highlights
team
of
just likes the
proposed
bars.
redactions. Mr. Ellis can make sure that your court staff receive that. and
Allegedly.
email you or print it out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
and
fair enough.
maximizing the time, because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair enough. The
minutes.
state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, let's go a little bit longer, just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there.
Yeah,
Court is
they
in brief recess.
definitely took a long break. Because
Gee.
we are 5 minutes behind.
Oh my
It looks
God.
like. Oh,
Maybe he decided to close the hearing. Who knows?
yeah, he can't pick and choose. I know. And YouTube is doing the, there we go, spinning wheel of death.
Court is back in session. Noting the presence of
I need a
counsel and all
gavel.
parties, I appreciate your
I need
patience.
to be like Charlotte
Sometimes
Dobre.
it takes time to
He
save
is the
time.
first
that was
judge,
the intent of this
real life
court,
judge I've seen with
in
a gavel.
addressing what is before this court as it relates to State's Exhibit 16.
I need to take
Counsel, this
a
time I've
little
taken
to
time
her
to
dad.
look at the video and you,
Yes.
also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to like scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript, as it relates to State Exhibit 16, may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I'm acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning.
All right, it sounded like there might have been a close here.
Until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Senator, would you state those times again that you are ordering not to be published? I got 3255 to 3548.
Right. Those are the two timestamps.
Oh, and
that.
for-
And I hope that's helpful as both parties.
For my comment, I'm a petty potato. For Charlotte Dobre, people who don't watch Charlotte Dobre, petty potato is kind of her her thing. For I don't know how it became a thing, but she has a couple million subscribers, and we're her petty potato family.
Oh, wow.
So, and hey, JKD Buck, welcome back. How are you? How is everybody? So, and Mr. Squid is home. The people still haven't been here to install this stuff, but I, as promised,
I could
did
say,
grab
did you crack open it? Okay.
I did. We have 4 left. We have 4 left and 3 Miller Lights that don't belong to me. But I text my dad and said, from the little's phone and said, Mommy says, come get your beer. And he never responded. So he's every time he comes over here, I'm like, take your beer home. Take your beer home. And he still hasn't brought his beer home.
I
And
did
that's
know.
the only alcohol that's in my house. 4 more of these and 3 Miller Lights. We're not a drinking family.
Drink that Budweiser.
Parties are trying to review on the transcript and in State's Exhibit
I'm
16.
from Wisconsin, dude.
That's the
If we're gonna drink a name brand, if we're gonna drink like a
is not
off-the-shelf
publishable
beer,
in the courtroom.
it's gonna be Miller
or on
or Line
TV
and Kugels.
broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your arguments succinct.
Yeah.
With that in mind, do the parties
Keep your arguments succinct, which means if Michael Burt is going to do the arguments, don't let him.
have any arguments they feel I have not considered in my ruling that require a closed hearing?
Oh, here we go
Yes,
again.
Your Honor. And so I'm just going to tell the court what I think the
I'm
general
going to
nature.
tell the court what I think. Please don't. Please. No, actually, you know what? Please enlighten the court because I really, really actually want to see this judge get pissed. So please tell the judge everything.
He's definitely gonna crack at some point down the line.
I hope so. Like, I don't want to be that person, but this judge needs to stick his boot up somebody's proverbial backside. These lawyers need to start tasting leather shoes.
He go home like, I just got on the bench in May last year.
I didn't sign up for this. Or he's going to be, was I this fucking annoying when I was a lawyer?
I believe he was a defense attorney. I believe he's the former defense attorney.
Yeah, and my thought would be, was I this freaking annoying? Because I've done that before. Like, I apologized to my mother when I had to deal with teenagers, and I was like, I apologize if I was that freaking annoying when I was a teenager. Yeah, it'd be nice to see the judge grow a backbone.
Yeah, this
Do we
judge
need to like
real-
do some stem cells transplants and like help him grow a backbone?
he likes to be nice, and I get that, but at a certain point,
Right now he's a
you can't let people walk all over you. I'm getting to the point where I like him, but I'm like, come on, man, this is, I don't know what I think of you.
Yeah.
Anymore.
he'll put in the golf cleats and stomp up someone's butt at some point. We hope so.
Yeah, you
Um,
know, I'm breaking
some tenderize someone's butt cheeks. You know.
They
Oh,
probably
I have a meat tenderizer that could probably be classified as a deadly weapon. The thing weighs like 3 pounds.
there probably ain't gonna be no testimony today.
I haven't drank in almost 10 years. I just lost the desire, but some of these people make me want to open up one of the bottles I still have around. I mean, they've aged, so they should be better now, right? Yeah, and the thing is like, we're not really a drinking family. And when we are, it's like, I think the most I've drank this year is I bought a 12-pack of those Simply Spiked limeades or lemonades and a 12-pack of these and a bottle of wine. And
So you mean you ain't never got stone cold drunk?
not in like the last 5 years.
Oh wow, okay.
I would say December 2020 is the last time I got like where I was like, I'm feeling a little nauseous.
Oh wow.
But other than that, no. I mean, I did drink on Thanksgiving of 2021, but then that following Monday I found out I was pregnant, so there was no more drinking after that. And then I just really haven't. I mean, every once in a while it tastes good, but I don't have the desire to go, "Hey, let's go get drunk." No. Like I go out with my friends every now and then and we have a couple of margaritas, but like we're eating and having a margarita with dinner. Like
You
we're
ain't
not just going out.
to like club taking shots.
I live in rural Georgia. We don't have clubs. We have bars. What? Wait, this last weekend? Yeah, I probably had more to drink this past weekend than I have in like in that short of a time because I drank 2 days in a row. I drank Friday and I drank Saturday. But like Saturday, I was drinking a margarita. I had 2 margaritas, or I had a margarita and a beer. But in the span of like 5 hours. So like I was drinking, but I wasn't like I was at a birthday party for a 4-year-old.
Oh, you talking about the 4th of July? Okay.
Yeah, the 4th of July. I was at a 4-year-old's birthday party with a swimming pool. So like I was spent most of my time in a pool. Yeah. But I had to wash down the spicy food.
You had that authentic stuff.
Yes, the little and I were the only 2 people there that didn't speak Spanish. Fluently speak Spanish, not like took Spanish in high school. Like Spanish is a first language and a dual language household type of
I'm just imagining you walking around with your phone using Google Translate to communicate with people.
Nope, it was authentic Mexican food. When I say authentic, I mean authentic.
Yeah, not that
Is
Taco
without getting
Bell.
into details, because I do think a closed hearing is appropriate. There are, okay, setting aside the 1102 issue and objections, there are
Setting aside the fact that I can't stand your ass and we are speeding you up yet again. I feel like I'm playing with this playback speed because I'm going up, down, up, down, up, down, up, down.
statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay, Mr. Robinson said. There are 2 other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay, I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said.
You were
in our
only
argument
supposed to
papers,
say
the
if you
answer is
wanted
no.
to have a closed hearing. What are you doing?
Publication, especially on
you
the
ever
way
get-
this proceeding is being.
Do you ever get secondhand embarrassment for people?
At this point with this guy, he made me regret liking defense attorneys. And defense attorneys are some of my favorite people, but at this point, I'm like, dang.
I understand everybody's entitled to a defense. However, some people, I feel like a public defender would do a better job.
And technically, Nesta the public defender, so that might not be the most accurate. But definitely, any other Utah
would
attorney
violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice,
It means more.
it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough, and so I want to make sure.
No, it was
is as the
clear. It
court
just
makes
doesn't
a
fucking
decision
matter.
based on, the arguments of counsel.
Your argument was clear. It just didn't land the first time, and it's not going to land the second time either because nobody cares.
All the court asked was, do either party had more argument that required a closed hearing, and he been going for about 5 minutes on whatever this is.
Yeah.
Counsel.
The
United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381
Estes.
U.S. 532.
E-S-T-E-S.
The
Estes.
following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson.
But that might be for trial. This is not a trial.
This is a professional judge. He's not a jury.
They were prejudicial in a trial. This is I have not read that case law, but I can take a wild guess.
He gonna make me look it up tonight.
I can take a wild guess that this is how you this is the next installment of Timu Law School and how to misrepresent case law 101. Yes, in a trial. Those cases probably referred to trial or pre-trial hearings, not a probable cause hearing. Not a probable cause hearing. I'm not a lawyer. I never claimed to be a lawyer. But I would think if you're going to cite case law regarding evidence allowed in a probable cause hearing, you would want to cite case law regarding a probable cause hearing and what's admissible in a probable cause hearing.
Yeah.
And I guarantee that those cases have nothing to do with probable cause hearings. I have not looked them up, but something tells me that they're putting the cart before the horse, and that has nothing to do with a probable cause hearing.
Some confessions, but that is what the state will call them.
Making me do homework.
And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology.
Hi,
I'm just going to use
other
what the Supreme
form of
Court says because it's the
technology.
Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial.
He said the 60s. He said the 60s. Oh my God. TV was doing the 60s. This dude said the 60s.
I caught him at the perfect. I caught this at the perfect freeze frame too. But thank you, Novak. Thank you for allowing me to. Speaking of other forms of media, how about other forms of income and my affiliate for this show?
If this dude is saying television in the 1960s, YouTube must break his mind.
Yes, but Flash fan, hold on one second. So thank you, Novak, since we're talking about alternative means of things, alternative media. Hi, hello, that's me. I'm a YouTuber. However, let's talk about alternative forms of income and alternative skincare. So instead of putting, crappy stuff and expensive stuff on our skin that has loaded chemicals in it, that are unknown and have long-term effects that we might not know. How about we put something natural on it, like F-balm, some tallow, only like 5 ingredients, including grass-fed tallow, olive oil, beeswax, honey, and frankincense. So much better for you. I love it. Honey is a natural antimicrobial too, so it's good for like burns, minor cuts, and tears. But use that link right there or that wherever that QR code is right there, or go to tellthetruth.com. Use code SQUID. You get 12% off. Thank you, Novak, for allowing me to share my skincare routine with you guys, since it's alternative according to mainstream media. And I am alternative according to him.
Dude
Trial.
said, I'm in the 1960s.
Violates Mr. Robinson's due process rights right here and now today.
That was the perfect segue. I could not have thought of any better
segue.
segue than that. Thank you, sir.
If I haven't been clear about the argument, I want to make sure I'm clear about it, because the court's decision to allow this video to be televised and the other two exhibits to be shown
he never-
on the camera in the back of the
He never said televised. He said the audio and the video could be played in the courtroom. He never said that the video could be televised or the audio could be televised. There's a difference.
I think he ruled against it being published in the courtroom. So what the heck is he talking about?
I'm not really sure. To be perfectly freaking honest with you, I think he's lost the plot.
I think something wrong with his brain. I say this with all the most. I'm not even trying to solve him at this point.
I'm not really sure there's one in there.
He needs to learn how to listen.
Are we sure there's one in there? Hello, sir.
At a point, this is just kind of stupidity. He not even listening to what the judge said. Like, he just said.
This is why I'm convinced, like, why he annoys me so much is because he thinks he knows more than everybody else. He's trying to tell the judge how to do things. He tried to tell the Supreme Court what to do, even though the Supreme Court said no. The judge said no. The Supreme Court said no, and he's still trying to tell the judge what's up.
Talking about, well, Your Honor, you technically, you didn't say it, but saying what I was saying, Your Honor, you can overrule this Utah Supreme Court.
We need an MRI to find if it's empty. Yeah, I think all we need is we need a flashlight, and we just need to look into his eyes and see if there's anything there. I don't know. A urinalysis test might be appropriate right about now, too.
Dick got big. Damn, my head against the wall.
Huh? I mean, like, because if you have a UTI, it can affect your cognition. It can make you very confused. So I'm wondering, sir, do you have a UTI? Curiosity.
Oh, man.
Just curious, because something's not right.
courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity, and perhaps, again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is
Doesn't even know.
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. It actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this?
Yeah, I want to make it clear. When I was referring to a urinalysis, I was referring to like the medical side and having a UTI and being confused at his age. It was an age joke and a medical joke. It wasn't a substance abuse joke. It was a medical joke.
I am just waiting to see.
Heidel got it.
I'm just waiting to see your name come up in a Tyler Robinson motion. I'm just waiting.
Hey, it might have more people watch my channel during a Tyler Robinson stream. They don't care about me.
Be like, so Your Honor, there's this YouTuber named Squid Pro Quo, and she said
He said I'm cognitively impaired and I need to go to the doctor to get a urinalysis because I might have a UTI.
I want to compel her to testify so I can cross his advert on that.
Bring it, mofo. Because I also had said, if we remember correctly on day one, that I had a really good attorney. And that if he wanted to try to shut down my First Amendment rights, I would kindly give him an anti-slap. Very, very, very kindly. An anti-slap right to the, Yeah, what's he doing with his arms? We're in a workout class now. Don't you know? We're combining ETM and squid into one. The Novak. We're gonna do an exercise class. We're gonna call it the Novak. Sorry, fucking have way too much fun. I am way too snarky for these people. Yes, but I just want to make it clear that was not a substance abuse joke. That was a UTI. That was a medical joke that might go over some people's heads.
We become unhinged after 5 p.m.
There's reasons I don't stream this late. And I've been streaming since 9:30 this morning. Like
Proceeding, the preliminary hearing.
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think the note that is referenced in Mr. Twiggs 1102.
Right, let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate
the Novak.
It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weighed in, my understanding is those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed.
we did read that on this channel.
And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm...
Technically, it wouldn't be a confession because it's not him. It's his roommate.
Yeah, that's not because that's kind of like, what do they call it, like double hearsay.
I said motion because somebody in one of their hearings went motion, motion, motion. Then I just
that's a good accent for you.
Speaking of motion, motion. Fuck. Why are people so easy to make? How many motion? Yes, Stacy knows motion of the ocean. No, the person who sent me a cease and desist and threw a hissy fit because I was talking about her in one of their last hearings. I guess I didn't listen in. I didn't bother to click the link and attend virtually. However, I heard people talk about it, and when she described her, I have motions. It's like
Southern accent.
no, I don't think that was a Southern accent. I don't know. Motion for the ocean is what a private thing. Yeah. Like, yep.
The state's counsel would never intend
I can't help
but
but
that
laugh
would
at
be
it
the
every time. It
consequence
just makes me
of
laugh.
further televising what the state refers to as
keep repeating
previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging.
I can't even get my
that they are
mouth to move
statements
like
of
that.
purport. We have not filed anything in this case that publicizes the text messages, the
Sorry.
Discord chat, the note which Ms. Hunt is mentioning.
If I'm the judge, I'm like, you waive your right to have a closed hearing because you keep arguing about this
video.
stuff.
That's another piece of the same problem.
They sound
So-
like a real tampon. Stuck up, miserable.
This is all
See you next
simplified
trial.
by the court being extra cautious about Mr. Robinson's constitutional rights.
Yeah.
Considering these
It was-
exhibits to the extent the court
fun-
deems that they're
fun
admissible,
experience.
portions of them are relevant.
Let me tell you.
And not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right, I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitor such that cameras can capture them and pause.
I just checked what we had in real time. I think
the
the media is going
I
to
believe that
object
was
to
the
the
media's
proposed
position,
proceeding.
if I
But
remember
they
correctly, is
talking
that they
to
want
get it.
everything audio and visually displayed. But the state's position is just we just want the audio played.
Right, but what's it?
Oh, and it's all right, guys. I thoroughly
I'm just focused on 16 right now.
typo.
Okay, yes, and that's the state's position with regards to Exhibit 16.
So help me understand, what's the difference if the audio is played or the video is played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that.
I can speak to that. I'll take a wild guess. You can't actually, when you're listening to the audio, you can hear what they're talking about, but you can't actually see the exhibits.
Yep.
There's a difference between reading what the exhibits are in a motion, hearing what the exhibits are, but actually seeing them are completely different things. Just
I want to like.
It's different
I
than the court simply reviewing it
want to
for
see what the
its
argument
own
going to be for this
privacy.
when we
I
get to
don't
a
want to
trial.
mistake your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call the
when
distinction
this
of
goes to
it doesn't matter whether
trial,
it's
I'm
audio
gonna
or
need
video.
you,
It doesn't matter whether it's on
DJ,
television or on the
Carmen,
internet or on the radio.
Gabby,
It's going to be broadcast.
Heidel.
So it
We're
doesn't
gonna
really
need the
matter
whole
whether it's
damn
audio or
crew
video.
to
And
make
it's
it
actually
through this
not
thing in one
Mr.
fucking
Robinson's
piece.
video, it's Mr. Tree's video. And when the court mentioned 403,
With
yes,
all
I
of
think
our
the court
brain
did
cells
accurately read my
intact.
mind, which is fine with me.
Yeah, 'cause
but
this thing probably gonna
it's
drag on
unfair
for
prejudice of a constitutional
weeks.
dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J
Jesus,
states
Pete.
that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then, in the future, move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with audio. But hearing the tone, the context, all of that. That's why the state chose to do. We could have done a written 1102 statement from Mr.
And they
Twiggs.
started
We chose
in
to do as is a
Huh?
There's been an hour or two without testimony, and they started late today in the afternoon. And they
It's
supposed
gonna be a
to go
long
feedback
day on Friday.
Yeah.
It's gonna be a long day on Friday.
Whew.
Yeah,
by
we're
1102, we chose to do a recording. Because
still
that's how the
15
state
minutes
used to present
behind.
this evidence. We believe that the appearance or
And they
the
still
tone,
arguing
the
in court, so
context,
I don't even know if
hearing
they
Mr. Twiggs actually talk
The-
and
the
talk through
minute
his exhibits,
that we
talk through
get
his
caught up,
experience is
if we get caught
a
up,
meaningful
that's
way
when I'm
to present our
stopping the
evidence.
stream
So
because
that's
I'm
the
like, I'm
difference
not
we see.
doing this shit no more.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. That's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations, because as Your Honor said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word
It's
from television to
not
electronic publishing.
him. How can it be a confession if it's not Tyler Robinson, you dumb...
And it.
Oh, God damn, my brain's about to explode. Hey, they're here. Hey, we're actually getting our new stuff.
Oh, cool.
They're finally here. They were supposed to be here between 1 and 4, and it's
That's crazy.
6:17
They-
p.m., and they're finally here.
So they do that. They buy. We're gonna be here this window. They come at like 7:00 at night.
They were supposed to be here yesterday between 12 and 4. No, 12 and 4, and they were here at 12:30. Yesterday they were great. Today not so much.
Because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
He wouldn't know case law if it smacked him in the face.
Citation to
California,
state standards for what is or is not a public document are not the issue. We have a constitutional issue here.
Look at
And I think the
McBride.
court
McBride is
has already
just
heard from me
like,
at least 3 times about what
just
we think the court should
get
do
this
here.
over with.
It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to forego.
There may be a jury trial in the future.
So
Sir,
that indicates that they're going to try to go for the Koberger defense. Get a plea deal. That
Sir,
statement. Yeah,
unless you plead guilty, there will be a trial in the future.
he's not looking forward to going to trial.
On yet another issue, which is whether potential jurors were exposed to media
Shut the fuck up.
replaying of what the state called a confession. That's exactly what was.
It's not a confession, you dumbass. It is not the defendant. Is there something that I don't know about somebody else being able to third party confess for someone else?
No.
Am I stupid? Like, don't answer that, but just.
I mean, we in the same boat, so we both are. If it's different.
Is there some law that I don't know about or some statute that I'm not aware of that that I'm just not aware of that someone can confess on behalf of someone else? Because that's just, why is he calling, the state's calling this confession? They never called it a confession, you dumbass.
They just called it his statement.
But it's the interview of Lance Twiggs. The only thing they mention is that in the text messages, he makes some confessions, which sucks to be him.
Yeah, but that comes directly from him if they can prove it.
If you are stupid enough to commit a crime, FYI in Minecraft, do not put it in text message. Do not put it in Discord.
Or record it, Sarah.
Do not be a Sarah Boone. Do not get drunk. Do not break out your phone. I feel like this is like a PSA. Do not. What is that cartoon? What is it? Dr. Seuss. It's Dr. Seuss. Do not. Do not eat green eggs and ham.
Yeah.
It's the green eggs and ham defense. Don't.
I will not eat green eggs and ham.
I will not eat it on a plane. I will not eat it on a train. Don't record your crimes. Don't text your crimes. Don't admit your crime. Like, just
don't talk to the cops.
Don't talk to the cops. Don't hand the cops your phone when you recorded your crime, Sarah. Sarah. Sweet little Samsonite Sarah.
Somebody asked me, do you know what's going on with her divorce case? I'm like, I've never followed that divorce case.
The divorce, I deal in documents, and the family law case are sealed.
Yeah, from what I understand, it's hard. Some people can get the document, but from what I understand, it's hard.
I am not special or privileged enough to have someone leak documents to me. So, if they ain't public, I don't get them. And that's one of the things that covers my ass, because when someone writes you a cease and desist, you're reading publicly available documents.
That's why I'm thankful to Andrea Burkhart for these documents, because if it weren't for these, I wouldn't be able to read these things.
Yeah, me either. Anyway, let's get back to Novak. Ben Stein's wannabe Ben Stein. Only Ben Stein's funny and entertaining, and Novak just makes me want to drink.
Was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. Right. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right, thank you. I appreciate both parties advocating and arguing it. It's helpful for the court.
It's not helpful for the court.
He just being overly nice to you.
Stop being nice. Start actually doing your job.
Trust me, I don't think this niceness is going to match at the rate this is going.
He's going to have a
coronary. Going to require to be redacted starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8.
I'm going to skip what they're redacting because we don't know what it is anyway.
Sorry, starting on page 7, right after 8, is that at 8? well, let's start. Starting on page 6. Starting on page 6, after 6 minutes and 56 seconds. Entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right. 6:56 until 7, just that the court indicated.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for your honor's consideration.
Right, so kind of going through my 3-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video. Is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance and everything that Mr. Novak noted.
I can't even remember his name.
He even got his name. He had a brain fart.
Because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where
Good, Mike. It's late.
as it relates to publication.
Yes, thank you.
All right, to the media.
It's late for this is the only thing I don't like about
Your
like
Honor, I know how much time the court's
mountain
already
time
dedicated to considering this,
cases.
and I appreciate the additional time being afforded to the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration
We
that the court is
literally
entering into,
got two
when
more.
trying to make the determination that
Almost like an hour and 40 minutes of court session left. But don't they wrap up like 5 o'clock daytime?
Yeah,
They almost over.
we might do tomorrow because this is giving me a headache. And if it's giving me a headache, it sure as hell is giving y'all a headache. Because how are we like only 14 minutes behind?
it is going to make a conclusion at this hearing. Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary
look
hearing
like
will
this
serve
still
decisions
fight
based on
in
improper
real
means
time.
and will promote conscientious performance by all officials involved in the criminal
Is
justice
he
system.
like 12?
Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings
You
can play a
old enough
significant
to be a
positive role in the
lawyer.
functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today, that many of these references are to text messages. Again, the public doesn't have access to them. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurked in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen.
Hold on.
Yep.
Let's Let's see what this guy sounds like at like 1.25 speed.
Because he sound furious sped up.
And here, need to. Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's
Him being
it, Your Honor.
sped up made him
To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system.
There you go.
And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you.
That is so
Anything
true.
further before I issue my final ruling to clarify what's been stated, just so it's clear?
I mean, that is, couldn't have put it any better myself. I mean, he's obviously close with the Kirk family, represents them, but it will create distrust, which is exactly what we saw in Carmelo Anthony when he didn't allow cameras, when you hid shit.
Yep.
Look what happened outside that courtroom. Do I think that same issue will happen here? No. However, Charlie Kirk died in public. Whether it was Tyler Robinson or not remains to be seen. However, Charlie Kirk died in public. He didn't get the luxury of privacy.
Yeah. At least with Carmelo Anthony, there might have been people there, but it was underneath a tent.
Yeah. Short, straight to the point, and expressed the frustration that all of us are feeling. I mean, I can't imagine how the Kirk family, his parents, his children, Erica, no matter what you think of Erica, at the end of the day, she did lose her husband. And the father, she is a single mother now. So that's why I'm like, be careful how you think what you think of her and how you talk about her, because she's a single mother of 2 toddlers.
I'm like, yeah, at a certain point, we all did or said something that maybe are questionable, but at the end of the day, she's still a victim. She lost her husband.
Yeah, she lost her husband. No matter what you think of her, she lost her husband. And try losing your significant other and then facing the public every day. And thousands of people who hate you and what you stand for.
And you still got to be there and be strong for your kids, because your kids lost their father.
Exactly. And your kids are going to see how you react every day. And you might not like her and might not like her as a person, and she might not be reacting the way you want her to react. And that's fine. But at the end of the day, she lost her husband. And to insinuate that she had anything to do with it when you have no proof is fucking bullshit. Fucking bullshit.
This is the court TV. They got this notification. It said Charlie Kirk hearing shot the towel, rifle, and disturbing DNA. Oh, the media in there.
So many places to go with that, and none of them are going to be ad appropriate for YouTube. So we're just going to move on.
All parties. Mr. Novak, your mic's muted.
Dude, I can't listen to you at
Ms. Kirk's
1.25.
position in the situation,
Nah, that no guy. He's hard to lift him up.
as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme
Matt,
Court
you
has
have
said
anything to do with it?
the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to
You don't know what a fair
Kirk family,
trial
with all due
is.
respect to the
You've
media,
shown
with
you
all
don't
due
know what a
respect to the
fair
public,
trial is.
the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance.
That's what voir dire is for. Have a good day. Thanks for hanging out. But that's what voir dire is for. And if you can't do that, then you suck as a lawyer. You should find another profession if you can't find a jury and you can't question people to find a non-biased jury. It sounds like a you problem, not a judge problem, not a prosecution problem.
The jury is going to hate this guy.
It sounds like a. I don't know one. Okay, like I know that there are unlikable lawyers, but generally every team has one lawyer that you're like, oh, I can see the jury like liking that person or like being able to connect with that person. I don't know one fucking attorney on this defense team that the jury's gonna be like, oh yeah, they're likable.
Maybe,
Oh yeah, they're relatable. I can see myself, you know.
Maybe Visica, we seen the least of her. You know, we've seen her yet, or seen her stage.
Yeah, the RBF queen. I thought my RBF was bad. Sticky Visser, girl. You might want to soften them cheeks a little bit. Just saying. Just saying. And I'm wondering if there's. Do you know? Look at his middle finger. So I'm gonna move us just a second. But look at his middle finger on the. We're gonna go up here.
Yeah.
We're going straight down. We're going straight down. We're just gonna let the long crime. Look at his middle finger.
Yeah.
You think that's intentional?
Probably. It probably for sure. If I had to guess.
To pretrial information.
I feel like I could make a meme out of that.
I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is
You've been trying to issue some final ruling for the past 15 minutes.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed rule that publicizing a confession runs afoul of the 14th Amendment. That didn't appear to be the holding. It was.
Sorry, I didn't realize.
Confessions being put out.
I didn't realize that we were covering the screen and y'all couldn't see that. Hey, Roy. Good to see you. Hugs, my friend. No, Heidel. That's not his pen. Look at his left hand. Look at his left hand. That's not his pen. This is not his pen. This is his middle finger. Who do you think he's aiming that at?
Even he's doing it in the video game. Even he's doing the Phoenix right there where you point your middle with the video game character, the attorney, and he he pointed his middle finger like Jackson shot real out and point their finger at the witness. Even he's doing that. He's just mad about that.
Yeah, I didn't realize that when we were down at the bottom, we were covering that hand. And when I saw that, I was like, oh, we got to move. We got to show this. Because that right there, that's, you don't do this. Like, you don't do this without knowing what you're doing.
I think you positioned us like that to cover the logo so they don't try to come after you.
Huh?
I think you had positioned us like that so the long crime will come for showing the logo.
Yeah, well, it also covers up, you know, you know, I generally don't care about covering up Law and Crime's logo because I stop so much and I talk over them and I
don't write them what they used to, but that was years.
Yeah, but I also speed it up and because I don't watch live, so it's like I do a lot of things that make it fair use.
Yeah.
So I never really have a problem, but I still do it just because. But with East Idaho, it was kind of perfect because their logo was up here in this corner. So
they feed with this
concern in this proceeding.
Maybe tomorrow.
Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom under this court's supervision with this court's guidance to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed rule that publicizing a confession runs afoul of the 14th Amendment.
Okay.
But that didn't appear to be the holding.
You
It
don't
was-
have
the
to
opinion
worry
talked
about
forced confession.
catching up. The trial, the hearing is over.
Oh, look.
I don't know more.
Oh, look at that.
Yep. So he ended early, I guess. I guess he's like, yeah, we're
Not getting anywhere. Let's just call this a fucking day.
Questions being put out to the public. Could you cite to Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was the case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession
When did
de
the
facto
prosecution
violates the
call it a
defendant's 14th
confession?
Amendment right to due process, without a prejudice analysis, without even looking at what happened in the trial
This
vis-a-vis
is the
that
defense.
earlier televised analysis. So,
This is
yes, we could go
Richard
down
Novak,
what lawyers do, we
aka
could go down the rabbit
Dicky
hole
Boy.
of what were all the different opinions in Rideau, and why is Estes citing to
A whole day of
dissenting justice? What
wasted
Estes said is,
on
we
this.
constructed a rule. It's not a reference to a dissenting opinion. And I think when the
Waste
Supreme Court
of
says we have a rule,
everybody's
we should just
time.
take it at face value that that's the rule.
I guess
I understand what's in
can't
parentheses
take any
there is a
more
little
heated
confusing.
drinks.
But what the Supreme Court is saying in Estes is, we have a rule. And if I may have one moment.
I don't see how this gonna wrap up by Friday, because the rate they going with this stuff, whole day was missed. We maybe had like 10 minutes of testimony.
It's one of
Estes'
the-
opinion was written by Justice Clark.
Hey, Harry.
There was a concurrence by Chief Justice Warren, Mr. Justice Douglas.
No, this
Mr.
judge set aside. So this judge set aside 5 days.
Yep. Monday
This was
through
not.
Friday.
This is not extended out. The judge set aside a full 5 days for this. This is not like extending out past where they wanted. This is planned time.
They
but
gonna have
it's-
to rush through tomorrow on Friday.
Yeah, this is planned time that the judge already knew that this was going to take 5 days. However, this is still, in my opinion, wasting the court's time.
Yeah, either they gonna have to rush through, or the state's gonna be forced to rest or stop their presentation because the stupid defense is making all these arguments. Pointless
So,
arguments.
and this is what this is what I dislike. Like when things take a long time, people automatically go, "Well, this judge sucks." It's like, well, no, there's a lot to it, and this was already planned out for 5 days.
Yeah.
They already knew this was going to take a long time.
And the reason he's hearing all these arguments out, this is a capital penalty case. You gotta make sure you be real careful when it comes to people.
Yeah, this is a death penalty case. You got to cover your ass. So you can't. There is no. Well, the judge didn't let me talk.
Because from what I hear, the appeals court looks at these type of cases even more so than regular cases.
Yeah. However, he is a little too nice to people, and does let people talk even when he's already made a ruling. That is where I feel like it's wasting the judge's time. And we could have gotten through this argument. The defense is just making stupid fucking arguments at this point.
Yeah, the whole afternoon testimony was missed because they was arguing over this stuff.
Like at this point, this makes Bubbles look like he's not wasting the court's time. But there's still 2 days left of this dog and pony show.
Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White.
I don't
So we
care.
could spend some time
Get to your point.
deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to 20 minutes and 20
Okay, I'm
7 seconds.
skipping through his
Draft
edits
report
though
ready.
because we don't know what those timestamps mean, so they mean nothing
Until-
to us.
From be included. The representative for victim
I
representative.
think he's
Erica
gonna
Kirk
rule it, and
is
it's gonna be
American-
over for the day anyway.
Yeah, it's just a thing.
Recognize the importance of transparency.
And they do have it
I
set
also
up
recognize
for
the importance of
7
balancing constitutional rights, and it is a fine line.
11,
9 a.m. their time.
9 a.m. their time. Okay, so we'll probably go at like noon.
Okay.
Noon. Yeah.
Fine. One of the reasons why for these edits includes
I might
your-
have to
my
leave
analysis
during
under
the afternoon
403.
session
Going
because
to
I
the
have
last part, needlessly
That's fine. You gotta do what you gotta
edits,
do. You've been
and
sticking
based off
with
the
me all
representation of the
week,
state
so
that the text messages
you've
may
been
be
suffering
introduced.
with me
The
through
court is ruling that
Novak
this may be
and Nestor,
revisited
or
in case that
Nestor.
doesn't happen.
I've
But,
enjoyed this,
to-
even though these attorneys are irritating. But
These
Friday,
attorneys,
but-
these attorneys, man. Holy shit. It seems like every set of defense attorneys that we see starts to get worse and worse. Worse and worse. And worse and worse and worse.
I
Like I
like the-
thought James Owens was bad.
I started out watching trials with defense attorney. I've always favored. I've always been a defense attorney heavy person.
I know, and I was always like an anarchist and hated the state because at the end of the day, even though this judge is like, I'm not on any side, technically they're both employed by the same people.
Yeah.
And when people are when both are being paid by the same entity, the state, I get very hinky and very suspicious. So with that, I've always been anti-state. I've always been anti-government. However, some of these defense attorneys, man, are really making me like question my will to live.
throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency, and sometimes it is an imperfect
Friday,
balancing
I'm
act.
all
But
day.
I'm trying to act in the
He
interest
might
of
go.
justice in making this balancing act and for
And
transparency.
Friday,
to
I'm in it for
actually
the
be
long haul because we got to
transparent.
finish this
That is
shit.
the ruling of the court as it relates
I don't
to
wanna do this
State's
on
Exhibit
Saturday.
16. Turning to the state, do you wish to make the edits as identified by
Y'all
the court and
sleeping
play
over
it
the weekend.
tomorrow, publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
If you would
Nestor's a
mind,
mind
when you have that
molester.
final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page. That what is before
Everybody
is being presented
understands
reflects that. So
that.
Everybody's on the
state,
same page,
simply
but we
allow
don't
everyone to
agree.
review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
Please say no.
All right.
Thank you.
Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
Go home.
Yeah, just a moment.
Of course.
Yeah, they going home because whole day wasted over arguments when you could have had maybe 2 witnesses.
They wasted a whole day.
Yeah,
I
they
know.
didn't
I know the
even
state's
finish- they
engaged,
didn't
but if
finish what
someone
they
could
first
send
witnessed
a copy of
called.
that to the court after it's been reviewed by counsel, so the court can review it to double check that it comports
He's
with
still
what
on
I
a
said,
witness
to make sure that
stand?
it reflects what I was intending to reflect. That way, we can save time as well.
Not all witnesses or defense attorneys seem sleazy, but
No.
these ones,
Not-
mainly Kathy Nestor.
You want a good example of good defense attorney watching Karen Reed trials, even though the state is.
Yeah. Those are defense
Judge, it's
attorneys
your
I can
position
get
that
behind.
We close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis, I'm sorry, Agent Davis. Agent Davis, as to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just
Please don't.
making the court aware of that. It's a
Your
much
girl's
simpler,
bladder is about to explode.
exercise. It's not nearly as complicated. I think that's the only one where we proposed other
We gonna have
redactions.
I was an argument.
But the publication question
No idea.
still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that.
You're an SD's issue.
And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the prosecution will call confessions. So
Can he
maybe
ever
that's
do
something-
anything
It was a
without his
different
hands?
prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made
For
public.
evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what
Will
you're
help us
citing tonight. It's
actually move
difficult on the
forward.
fly to jump into SDs and go to a portion, and I want to give your argument full consideration. And it's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says,
AKA,
I'd like to
you're
know
not
which
sleeping
exhibits
tonight.
and what the legal issues are ahead of time, so that at 9
Yeah.
a.m.
2
the court has had
days.
an opportunity to
That's
already had an
what
opportunity
the
to
work.
understand what's coming. We're happy to do that, and I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you, Mr.
problem.
Novak. And if you
Not-
don't mind, obviously, sending a copy to the state as well.
Of
so it's
course,
not
of course.
as far as-
AKA, you're not sleeping tonight. Get your ass out of my courtroom and get your ass to work.
They could have shown each
All right,
other.
Is the court referring to a formal filing?
Oh my
No,
God,
just,
shut
uh,
up.
if you
A bench
want
memo.
A bench memo.
Shut the f- God. So, oh, it's worse. It's worse. It is worse. It is worse. I prefer James Owens. Cause
Yeah, that's why I said I prefer James Owens and people over these people. Owens was just
James Owens was
he was just evil with some of the stuff he was arguing that he would make, but even he's better than
these
these.
people delayed a preliminary hearing for 10 months.
And trying to
Let
force
that
the
sink in.
and trying to force the state to stop before they can even. They're gonna have to rush through tomorrow because you still gotta get through the defenses, people.
Oh, and Kathy Nestor, we're not even going to get started. However, they are done for the day. They're done.
Yeah, they'll be back tomorrow. Probably for more additional arguments.
They're done. So I'm not going to watch this, but y'all really should watch that video that just popped up from Larry about Judge Gilday. That's another judge where I'm like, dude, what the hell? So with that being said, I do have us set up to redirect over to Mo and Shizzy. Schmo. Schmo. Don't tell him I said that. Don't. Schmo. Schmo. I've had enough. Captain Kern doesn't start till 8, so but Mo and Shizzy start at 7. So do check out Captain Kern. He has a stream at either 8 or 8:30 Eastern time. He is talking about the 3D printing and banning, fact versus fiction. I definitely think you should check that out. But in the meantime, before that stream starts, Mo and Shizzy are talking the roasting the lol cow. If you know, you know. Schmozy. Yeah,
It's a chapter day. This is like working 9 to 5. The stream is at 9 o'clock this morning.
I made lunch. Had to clean up some bodily fluids around my house. And got back to work, and here I am. And now I have to go empty my bladder before I empty my bladder on this chair. So with that happy note, y'all tell Mo and Shizzy that I sent you. Thanks for hanging out. Thanks, Rumble, for hanging out with me. Y'all have a good night. I'll see you tomorrow at about noon. Well, 12:30. 12:30, because your girl's got errands to run in the morning. But 12:30, we will start.
I get been a little late tomorrow.
We will start day 4, and we will just see how far we get before our brains want to explode. And then we will move on to day 5 and try to figure that out. So y'all have a great night, and I will see you guys tomorrow. Remember, try not to be this defense and a bunch of twat waffles, and y'all have a great day.
Bye.
Bye.